This week, I was confused by news that a man was acquitted of charges of the R word by the Supreme Court of Minnesota because the victim was drunk. I thought there must be more to the story that I was missing. If being drunk is consent to sex, is it consent to other things too? What about theft? If I asked a drunk man in Minnesota if I can have his wallet, can I then take any response as a yes, as he's too impaired to refuse? I expected someone to respond that I had it wrong and to explain more facts in the case that made the whole thing make sense, that the headlines were just attention grabbers and the real story was just a minor issue. But I didn't get any response like that. So I looked into it for myself, and what I found was the facts were not less shocking, but more shocking than what I expected. Let's have a chat. Hello and welcome. The case that is in the news about Francois Khalil, whose conviction on the charge of first-degree criminal sexual misconduct was overturned because his victim was drunk. It is factually accurate as reported and is not just attention-grabbing headlines. First, I would like to point out that throughout the rest of this video, when discussing sexual assault, I will be using a male pronoun for the perpetrator and a female pronoun for the victim. I realize that this is not always the case. Females can be criminal aggressors and males can be victims. I am using these pronouns both because it is the most common scenario and because that is the way the facts are in this case. I am not trying to be insensitive to male victims. I know they are real people too. Reading the facts as reported in the Supreme Court ruling as to what happened was this. The victim was out partying with a friend. She was 20. I say was because it happened 3 years ago and she is no longer 20. She was so drunk that when the pair went to enter a bar, the bouncer refused her entry because she was inebriated and also because she was a minor. Outside the bar, Khalil's cousin, and another man invited the pair to a party. They accepted, and Khalil drove them all to a residence. There was no party. The friend says that she saw the victim immediately lie down on a couch and fall asleep. She says that Khalil sat next to the victim and also fell asleep. Khalil's cousin says that the two were seated next to each other talking for a while before they both fell asleep. At some point in the night, the victim woke up, face down, with Khalil on top of her and inside of her. She told him, "No, I don't want this." But he responded, "But you're so hot and you turn me on." The victim then lost consciousness again. The friend said at some point in the night she tried to awaken the victim but was unable to. In the morning, the victim woke up with her shorts around her ankles and she recalled the events of the previous evening. She found her friend and they left. During the ride home, the victim told her friend that she was raped. The state charged Khalil with 2 counts of first-degree criminal sexual conduct and 2 counts of third-degree criminal sexual conduct. These are the facts as reported by the Supreme Court. So regardless of conflicting stories or any possible he said, she said, this is what the court found to have happened. There is nothing in the case to indicate that Khalil ever claimed that the victim consented. It's possible that he argued that at trial. But since it was not in the facts found by the court, it is not a contention that is under consideration. Because it is not in the facts, if Khalil made that contention at trial, it was found not credible. So when we look at just what happened at the residence, a woman was sleeping. A man decided to help himself to sex with no consent. She wakes up, tells him no, but he ignores her wishes and continues to violate her despite being told explicitly that she did not consent to sex. Yet he continues to force himself on her. He is charged with rape, but then his conviction is overturned because she was drunk. She explicitly told him no. Is the court saying that a woman who is drunk but still has the mental capacity to say no to sex has given up her right to refuse sex due to mental incapacity to refuse? It would seem so, but that's not the way the law works in Minnesota. The court was looking at whether the victim was incapacitated to the point where she was unable to give voluntary consent, yet she was not incapacitated. She said no. The first question that I'm asking is why the question of mental capacity was even discussed, as the woman clearly had the capacity to refuse, because she did refuse. I'll answer that question in a few minutes, as it's a little complicated. That Khalil decided to help himself to a sleeping woman without bothering to ask for consent has nothing to do with her being drunk, or even asleep for that matter. If you are thinking, how can a man penetrate a woman without consent if she was awake and in full control of her faculties? I've seen it done. I was working at a truck stop. The manager was a 19-year-old young man. The 17-year-old male cook bet him that he could digitally penetrate one of the waitresses before she could stop him. I heard all of this and told the waitress. When the waitress entered the kitchen, he did it. He was too fast and too strong for her to stop him, even though she knew he was planning to do this. She wasn't drunk or incapacitated in any way. Incidentally, nothing ever came of this incident. The waitress slapped his face. He accepted it, as he knew he deserved far more. Then he collected his $20 bet. End of story. The second scenario that can occur is where a man just helps himself to a woman and the woman says no but does nothing. There are many reasons why a woman who doesn't want sex will also not resist. It doesn't make it any less of a crime that the woman's refusal was only verbal. Verbal denial of consent is enough. Non-consensual sex is rape. We need to make that a legal reality everywhere. Getting back to Minnesota. So the victim's status of being drunk should not have even entered the picture, as it had nothing to do with the victim's ability to say no, unless it was brought up by the defendant as a defense that she didn't have the capacity to withhold consent. But this would turn criminal sexual misconduct on its head. If the victim being drunk is an excuse to be permitted sex without consent, then all drunk women are fair game in Minnesota. It gives a whole new meaning to the phrase happy hunting. This is absurd. This isn't how the case was decided, but it might as well have been, because the result we end up at is the same. What baffles me is how utterly incompetent the prosecuting attorney was in this case. It is really the malpractice of the prosecutor that has led us to this ludicrous position. I'll show you what I mean. To do so, we have to go into the Minnesota criminal sexual conduct statutes. Minnesota has 5 degrees of criminal sexual conduct. At first glance, they all appear to be quite similar. There is similar or identical wording to several of the subsections. This chart helps. 5th degree criminal sexual conduct is a lewd act or one other thing that we will get to later. 1st and 3rd degree criminal sexual conduct involve penetration, and 2nd and 4th involve sexual conduct without penetration. The difference between 1st and 3rd and between 2nd and 4th is based on many factors, including who the victim is, the use of force or coercion, the use of a weapon or the threat of a weapon, the relationship between the victim and the perpetrator, and a few other factors. Khalil was rightfully charged with 1st degree criminal sexual conduct. The statute reads, "A person who engages in sexual penetration with another person," skipping over some parts that don't apply here, like the victim is a minor, "is guilty of criminal sexual conduct in the 1st degree if any of the following circumstances exists. E. The actor causes personal injury to the complainant and either of the following circumstances exist. 1. The actor uses force or coercion to accomplish the act. Or 2. The actor knows or has reason to know the complainant is mentally impaired, mentally incapacitated, or physically helpless. Neither mistake as to the complainant's age nor consent to the act by the complainant is a defense. So first, this statute gets around a consent defense, as people in this circumstance, as well as in other subsections, are unable to consent. The prosecution focused on subsection 2, as Khalil knew the victim was mentally impaired or mentally incapacitated due to being inebriated. The definition section defines mentally incapacitated as mentally incapacitated means that a person under the influence of alcohol, a narcotic, anesthetic, or other substance administered to that person without the person's agreement lacks the judgment to give a reasoned consent to sexual contact or sexual penetration. The defense argued that since the definition of mentally incapacitated only applies if the alcohol or other substance was taken involuntarily and the victim drank voluntarily, she could not be incapacitated by the definition of the statute. The appellate court ruled that the involuntary ingestion applied only to other substances, as first it modifies administered to, and that a person who drinks alcohol is not administered alcohol, they imbibe it. The statute could not have intended the voluntary exception to apply to the consumption of alcohol. The Supreme Court of Minnesota disagreed. They took the voluntary exception to apply to every part of the sentence and not just to administered substances. Thus, the Supreme Court of Minnesota sided with the defense, as this is a more natural reading of the statute, and the court cannot write the law. They can only interpret the law. And while courts do sometimes interpret things into or out of laws that clearly violate the original intent of the law, they can't just blatantly disregard the law. To decide that whether or not the alcohol was ingested voluntarily or not would be too far a stretch to take that to be what the lawmakers intended, in my opinion. But, as Charles Dickens so eloquently put it, "If the law supposes that," said Mr. Bumble, squeezing his hat emphatically in both hands, "the law is a ass." Which is why the people of Minnesota in particular, and the nation in general, are flabbergasted that the law seems to say that drunk people are fair game for sexual assault in Minnesota. There is a group in Minnesota currently working to reform the law. I hope they are able to do so, because as laws go, this is one that makes me question the sobriety of the lawmakers that passed it at the time. But regardless of what the law says, and with regards to the mental incapacity of the victim of sexual assault on the basis of intoxication, there are other components to this law that apply here. The subsection says mentally impaired, mentally incapacitated, or physically helpless. And physically helpless is defined as: physically helpless means that a person is A, asleep or not conscious, unable to withhold or withdraw consent because of a physical condition, or unable to communicate non-consent, and the condition is known or reasonably should have been known to the actor. The victim here was asleep by the court's own finding. I cannot comprehend why the prosecutor didn't focus his or her case here instead of on a claim of mental incapacity due to inebriation. The appellate case says in a footnote that this was argued. The state asserts that even if the district court misinterpreted the meaning of mental incapacitated, any such error was harmless because the jury may have found that J.S., this is how the victim is identified in the case, was physically helpless. We disagree. When it is impossible to determine whether a jury relied on a theory based on an incorrect statement of the law, we cannot conclude beyond a reasonable doubt that the improper instruction did not have a significant impact on the verdict. The jury specifically inquired about mental incapacitation. Because it is not possible to determine which theory the jury ruled upon in reaching its verdict, we must determine whether the district court properly instructed the jury regarding the definition of mentally incapacitated. In other words, the argument cannot be made on appeal that the jury would have found her to have fit the definition of helpless, since there is no indication that this was the basis of their verdict. But it should have been. It should have been the only argument here, since physically helpless is defined as asleep or unconscious. The victim clearly was helpless, and this should have been all that was needed to be proven here. I am baffled as to why the prosecutor would even try to argue for lack of capacity to consent due to intoxication. It's possible that the prosecutor argued these in the alternative, but if so, the jury should have been asked to make separate findings on these bases. Then this issue would be before the court on appeal, and not just speculation of what the jury might have thought on the issue. I can see one reason why the Minnesota legislature might have written the law the way they did. If a drunk person lacks capacity to consent, then all sex with a drunken partner is criminal, as no one who is drunk can consent. And while I see this raising some questions like, how many drinks before I consider my partner unable to consent, I also don't see a problem with erring on the side of caution. If you have any question about your partner's ability to willfully consent, you really shouldn't be having sex with them. Why not wait until they are ready? Isn't that what a loving partner would do? The next issue I looked into was, what about after the victim woke up, said she didn't want sex, and Khalil continued to have sex with her anyway? Shouldn't this be sufficient for a conviction? This is a second area where I found the Minnesota law to be appalling. The answer is, it isn't a felony. If a woman says no, but a man has sex with her anyway, unless he used force or a threat of force, or she fit one of the other definitions for lacking the ability to consent, or there was a special relationship, it is a misdemeanor offense. Injuring the victim is listed as a reason to make it a felony offense, but only if coupled with an inability to consent. Yes, I'm serious. It is a misdemeanor to have sex with an unconsenting partner in Minnesota, provided you don't use force or the threat of force. Incidentally, there is good reason to believe that the victim in this case was injured. The subsection the prosecutor was using requires an injury as an element of the crime. One of the defense's complaints to the appellate court was denial in discovery of pictures of the victim's vagina. The fact that these photos were part of the case is an indication that there likely was a visible injury. Non-consensual sex in the Minnesota Criminal Code falls under fifth-degree criminal sexual conduct, along with lewd acts. It is punishable by no more than 1 year in prison, a $3,000 fine, or both. A $3,000 fine? It sounds a lot like the Catholic system of selling indulgences. It's okay to sexually violate a woman. You just have to pay the state $3,000 for forgiveness if you're caught. If you're a repeat offender, it does become a felony. So I guess everyone gets one freebie, or close to it. The law goes back to old rape laws that required the victim to resist and or provide corroborating evidence of sexual assault. Minnesota dropped these requirements when they revised the law, but they did not go as far as to make it a felony to have sex with any unconsenting adult, only one that can't consent, provided that you don't use force or a threat of force. So the fact that our victim in this case explicitly refused sex doesn't matter. If she doesn't resist forcing the perpetrator to use force, she isn't a victim of sexual assault unless she lacked capacity to refuse to consent. That's why the prosecutor went for the argument that she lacked capacity to consent, even though she clearly did have capacity as she refused consent. But her explicit statement that she didn't want sex wasn't enough. The actual lack of consent doesn't matter. Does anyone really think it's okay to have sex with an unconsenting partner? How is this not rape in Minnesota? Minnesota needs to update their law, not just in the area of capacity to consent if you are drunk, but also that sex with an unconsenting partner should also be a felony crime. I hope Representative Kelly Moeller is successful in getting Minnesota law updated and brings the statute into the 21st century. I have considered one other possibility in this case, but this is speculation on my part. Since the victim clearly was helpless, as defined by the statute, and this case should have been an easy win for the prosecution, it's possible that the prosecution focused on the drunk aspect to allow this case to get the notoriety it is getting to spur change to the Minnesota law, knowing that they can still get a conviction in the retrial. If this is the case, and I hope it isn't, they have played with the life of the victim, drawing the trial out for years, putting her tragedy in the spotlight. We might eventually get a good result that will help others in the long run, but using someone's life and putting them through this is far too high a price. I hope this wasn't the strategy of the prosecution in this case. If it was, the prosecutor is just as guilty as Khalil in violating this victim, violating her rights, her privacy, depriving her of the peace that she needs to move on with her life. Good luck, Representative Moeller. Live your life.